Okay, well, good afternoon, everybody. Lovely day outside, Saturday afternoon. What a good time to study tort law. Okay, so today on the menu we shall be reviewing defences to negligence, and then we'll be getting on to private nuisance, which we did have an introductory look at last time. So we'll finish off private nuisance today, and maybe we'll get on to public nuisance, okay? But I will be making some comments about the assignment, because question 2 of your assignment is on private nuisance. So after today, everybody, exciting, you will be able to do question 2 of the assignment, okay? Question 1, you should have already done it, okay? So I'll keep getting questions about the assignment, but don't worry, I'll take you through the important points about the assignment later with regard to structure and format. And then so that will be it on the assignment. And also, yes, the course manuals are sufficient for the assignment. They're sufficient for the whole exam. But of course, if you want to do extra reading, no harm with that. I mean, if you want a good book on contract law, there's one called Contract Law in Hong Kong. Yes, okay. So that would be a good book for the contract part of the course. And of course, I mentioned Rick Klopczewski's book. Hang on, I've got problems with sound. Let's have a look. If anybody has problems with sound, let me know. Okay. All right, can hear me. All right, okay, well, that's good to hear. Well done. Can hear me now. All right, good. So we will be, after today you can do your assignment. So my suggestion is do it, even though it's not due until 23rd of March. You should be able to. You should be looking forward to it. Okay, hang on. Somebody can't hear anything. Cheng Hon Mun. Everybody else seems okay. So I don't know. Cheng, maybe you've got Wi-Fi problems or something. Okay. All right, so anybody else, let me know. I still can't hear anything. All right. All right. Let me write that in, type that in. Okay. I will always do these little problems. Okay, so well, I'm not sure what I can do, because everybody seems to be able to hear me okay, except for one person, so I don't know, perhaps you need to turn up your machine or something or other. Okay, so if you do have any problems, well, not only with the sound, but anything else, just let me know, okay? So I'll just wait to see if we've got any others with problems with sound before we carry on, but according to my machine, everything should be okay. I'm using a microphone. Microphone's working well. The staff checked out the sound, so that should be okay. Anyway, so I will assume that everybody is okay with the sound. All right, I'm just waiting to see. I've got Soon King Ning is typing. Let's see what he says. If he can hear me, then I guess we'll go on. Okay. All right, so that's our program for today. So I'll assume everybody's okay, unless I get something from you in the chat box. Okay, the chat box at least is a good fallback, I guess. All right, so let's have a quick look. Remember, everybody, this is a quick run through everything we covered last time. Remember, with regard to negligence, the plaintiff has to prove all the elements of negligence. The defendant has to prove any defense that he might rely on. Okay. Sorry, I could hear at this moment still, but I'm using phone only. I can use, okay. Oh, not sure what that means. All right. And then with regard to the defences overview, remember the two total defences, Valentine and ex turpi causa, which if they succeed, the plaintiff gets no compensation, because remember the main function of tort law is compensation. So the courts don't like those total defences, but of course it's still possible for those defences to succeed. And then, of course, the most important one, contributory negligence. So I'll mention section 21 of LACA because it's such an important section. Absolutely must know. So I trust you're drawing up your list of must know statutory provisions as well as your must know cases and as well, of course, as your must know definitions and principles. Okay, which one does the court favour? Well, that's an easy question, isn't it? Obviously, contributory negligence, because it's now only a partial defence under the legislation, and it's the legislation that governs now. Contributory negligence used to be a total defence, but no longer. Okay, so Valentine, quickly through Valentine, because we covered this a couple of times now. Remember, it's a voluntary assumption of risk. It is a complete defence. The defendant has to prove that the plaintiff had knowledge of the risk, agreed to accept the risk, and you don't need actually a formal agreement, it would be apparent on the facts of the case, and then had acted voluntarily. And then the must-know cases on Valentine, I would suggest Shatwell on page 121, which the explosives experts were too hungry and they didn't follow the full safety procedures, and so Valentine succeeded in Shatwell. Contrast Dip and Film Power, where the stuntman didn't agree to the less than satisfactory safety measures. Okay, so they're two good cases to remember, because when you're dealing with any legal issue, it's good to have one case that goes one way and another case that goes the opposite way on reasonably similar, not identical obviously, but reasonably similar facts. Okay, and then Morris and Murray on page 123. Remember, clearly there was Valentine there because the passenger knew of the risk. There was obviously a tacit agreement, and he voluntarily got on the plane. Valentine did succeed there, but the important point, which I keep saying, is that the plane was not a vehicle on the road. If it's a vehicle on the road, remember in Hong Kong there are statutory restrictions on Valentine under Section 12 of the Motor Vehicle Insurers Third-Party Risks Ordinance. Okay. Also, the other cases which have succeeded in Valentine, Titchener, so be careful when you're crossing a railway line. That's page 121. Geary is the one who was riding down the banister, so don't get overexcited now that the restaurants are open till 10 p.m. Okay, and then I've got Dan and Hamilton. No, the Geary is the one. Okay. All right. By the way, in Nettleship and Western, it's interesting on page 120. You could put an argument in Nettleship and Western. It was the driving instructor who got injured when the learner driver crashed the car. Was there Valentine there? Well, the instructor knew what he was doing. Well, he was instructing somebody. He knew what the risks were. There was a tacit agreement, and he had acted voluntarily. But remember, in Nettleship and Western, it's a vehicle on the road. Valentine does not work if it involves a vehicle on the road. Your course manual on page 120 should have emphasized that, okay? So in Nettleship and Western, the defence that did work was contributory negligence, which we're going to mention again later. So Nettleship and Western, everybody, really good case, because it's the case that tells you that the standard of care for a car driver doesn't change, it doesn't vary, it's that of a reasonable, competent driver. So that's the important thing about Nettleship and Western. But also in Nettleship and Western, good case on defences. Valentine did not succeed because of the statutory restriction involving vehicles on the road, but the defence that did succeed in Nettleship and Western was contributory negligence. So Nettleship and Western must be on your must-know case list. It's a very useful case. All right, and then moving on. Suicide, let's not worry too much about suicide. Well, we should worry about it, but not for our course purposes. Valentine is not applicable anymore, even where the victim is of sound mind and knows what they were doing. The Reeves case has changed the law, and the relevant defence when there's suicide will be contributory negligence. Okay. By the way, in the orange case, which is not on the PowerPoint but on page 124, Valentine did not succeed in the orange case. The Orange and the Chief Constable, West Yorkshire Police. And the main difference was that the police had no knowledge that the man had suicidal tendencies. Okay, we don't expect every prisoner to, commit suicide. Okay, so that was a case that goes the other way. So perhaps I should add orange into my PowerPoint. But anyway, you could make a note of that. And then with regard to rescuers, generally Valentine is not applicable to rescuers because of the situation. Okay, and you're acting to save somebody's life. If you sort of stop, hang on, I might not get any damages if I get injured. You're not going to stop and do that in an emergency. And so the courts, such as in Haynes and Harwood on page 125, the defence of Valentine did not succeed because when the policeman was injured in trying to stop horses from running into a crowd of people on a street, well, you're not going to stop and say, hang on, I might get injured here. So, we want to encourage people to become rescuers because, save somebody's life, very important. And so Valentine is not applicable to rescuers. Okay, and we've got the Hong Kong case of Tam Xiao Fong on page 125 as well, an attempt to restrain fighting. Okay, well, I mean, you're trying to break up a fight, which is always dangerous, and Valentine did not succeed in that case either. All right, so moving on, the statutory restrictions on Valentine. The first bullet point, everybody, is really contract law. Remember, there could be an exemption clause in a contract. Remember, we're talking about Valentine here. Is there some sort of agreement where, which could act as some form of exemption clause? Okay, but remember, from our contract law, section 7 sub 1 of the CECO says you cannot exempt liability for negligence causing death or personal injury. You can exempt liability for other types of damage under section 7 sub 2, but only if it is reasonable. Okay, but as far as we're concerned on this course, my suggestion is the second bullet point is must know. Okay, as I say, it should be in your course manual because I think you'll all agree with me, very important. It affects everyone in Hong Kong who rides in a vehicle on the road. Passenger agreements shall be of no effect. Can't be clearer than that. And a case you can cite is Pitts and Hunt. Pitts and Hunt, everybody, is a must-know case. In Pitts and Hunt, obviously the motorcycle rider knew the driver was, he was not licensed, he was underage, he was drunk. But the motorcycle rider knew what he was doing. There certainly looked like Valentine and Pitts and Hunt. But remember, a motorcycle is a vehicle on the road. So that defence of Valentine did not succeed in the English case. England has legislation very similar to Hong Kong. Okay, the defence that did succeed in Pitts and Hunt, everybody, was the defence of ex turpi causa. And Pitts and Hunt, there it goes again on page 127. All right, Pitts and Hunt, everybody, I must know case. I mean, it's almost like an examination question. Okay, advise somebody, advise the motorcycle rider who wants to claim damages for negligence. Well, the relevant defence would be ex turpi causa or illegality. All right, so remember, the plaintiff's illegal conduct may deprive him of a tort claim, and in Pitts and Hunt, the motorcycle passenger was committing a criminal offence where he was encouraging the driver to drive recklessly with the intention of deliberately frightening other road users. Okay, well, a car is a lethal weapon. Okay, so that's obviously a crime, and remember, what are the elements, though, that the defendant's got to prove? He's got to prove that the plaintiff was acting illegally, Pitts was acting illegally, the injury was closely connected to the illegality because there was an accident that occurred, and it must be sufficiently serious, the illegality, and certainly the crime that Pitt was guilty of was sufficiently serious. Pretty well all crimes are sufficiently serious, but not wearing a seatbelt, okay? So I like Saunders and Edwards because it has this graphic imagery of Madam Justice lifting up her long skirts and running away, but she won't do so at just the first hint of illegality. It's got to be, well, I mean, there is that debate, which I think I've got next, okay? How do you measure illegality for sufficient seriousness? Okay, well, a good question, but certainly not wearing a seatbelt would not be sufficiently serious to ground a claim in ex turpi causa, okay? All right, so Pitts and Hunt, good case, good case. In Pitts and Hunt, all the elements of Valentine were satisfied, but because it's a vehicle on the road, Valentine did not succeed in Pitts and Hunt. Ex turpi causa or illegality did succeed as a total defence in Pitts and Hunt. Good case, good case. Okay, now getting on to the most important defence, contributory negligence, which you know all about now, don't you? So we're doing this by way of revision. And remember, the relevant law now with regard to contributory negligence is Section 21 of LACA, which is coming up. So what is contributory negligence? It's the plaintiff's failure to take reasonable care for his own safety. So the plaintiff must be at fault. How do you know you're at fault? Well, he hasn't come up to the required standard. Okay, so then, of course, the negligence is either a cause of the accident or causes a worsening of the injury or damage. Okay, so the must-know piece of legislation is, oh, by the way, the defendant has to prove that the plaintiff's conduct falls below the standard expected, and number two, also has to prove causation. So watch out for that. The defendant has to prove those two elements, that the plaintiff's conduct falls below the standard expected and that there was causation. And of course, the legislation that you must know, Section 21 of LACO on page 130. And remember, this replaces the common law. That's no longer the law. And remember what the word law means, that which is laid down. Well, the legislation has been laid down. It replaces any common law on contributory negligence, and at common law before the legislation, contributory negligence was a complete defence, even if the plaintiff was only very, very minimally at fault. I've got 1% on the screen. Okay, but now we have this principle of apportionment, and this comes from the wording of Section 21. And Section 21, remember when you've got legislation, what do you do with it? Read it. Where any person suffers damage as the result partly of his own fault and partly of the fault of the other person or persons, a claim in respect of that damage shall not be defeated by reason of the fault of that person suffering the damage, but the damages, it's interesting, good exercise here in making sure you know the difference between damage and damages. Damages, damage, you know, personal injury, death, property damage, but damages is money. But the damages recoverable in respect thereof shall be reduced. Keyword reduced. By how much? Good question. Well, to such an extent as the court thinks just and equitable. It's up to the court. So if you're advising any plaintiff who says, well, what's this contributory negligence all about, lawyer? And you mean my damages will be reduced? Well, how much? Everybody's interested in how much. Well, the answer is you can't say. It's up to the court. As the court thinks just and equitable, having regard to the claimant's share in the responsibility of the damage. Well, the court has to apportion the blame, if you like. So do we have any guidance, though, on these numbers? Well, yes, we do. And we'll have a look at those cases in a moment. But first of all, remember the defendant's got to prove that the plaintiff falls below the standard expected. and the standard would be that of a reasonable person. And Ho Wing Chung follows the English case of Froome and Butcher that with regard to seatbelts, a reasonable person would wear a seatbelt. Okay, good. But remember, who is the reasonable person in the circumstances? Well, Chan Wing King, the pregnant lady, she did not wear a seatbelt, and the court said it was reasonable that a person in her situation would not wear a seatbelt. Okay, well, that was the decision of the court. And also, of course, there's got to be, and of course, with regard to other possible plaintiffs, it depends on who that is. As with the defendant's standard of care, children are treated as ordinary children of that age, and similarly with other types of plaintiffs. Causation. So remember, the defendant also has to prove that the plaintiff's negligence was a cause of the accident or of some of the damage. And so the defendant's got to prove some evidence of causation. And they failed to do so in Wong So Ching. And so in Wong So Ching, there was no contributory negligence because there was no causation, because the injuries would have been caused even if the plaintiff had been wearing a seatbelt. Well, that's a matter of expert medical evidence as to whether that was the case or not. So Wong So Ching, everybody, must know case. Ho Wing Chern, must know case. And these cases on the screen, everybody, are pretty good, in my humble opinion. Summary of, with regard to apportionment, pretty good summary of cases, which gives us some rough idea of the apportionment. So first of all, of course, how much will the damages be reduced by? Well, as the court thinks just and equitable, and of course the court looks at the relative fault of the parties as well as the causation. All right, so that's the wording of section 21, and then all these other cases simply are individual applications of that. Okay, but remember though, in each case, it's up to the court, and there's, the courts don't have to follow those previous cases. And indeed, as we'll look soon, in the case of Young and Chu, Madam Justice Yoon says there's little value in citing cases for the apportionment of liability, but it's still interesting to find out. I think probably it's the seatbelt cases which are the must-know numbers, if you like. The range will be between 15 and 20%, 25% reduction, depending on whether all or some damage would have been avoided. If all the damage would have been avoided by wearing a seatbelt, well, the reduction will be 25%. If only some of the damage would have been caused, well, that's 15%, or between 15% up to 25%. So Ho Wing Chern, must-know case, good case on the standard of care that's supposed to be applied to the plaintiff. Remember, a reasonable plaintiff would wear a seatbelt. Wishing Long Hong, our good friend Wishing Long Hong, good case to remember. Okay, and you can remember it just as Wishing Long Hong, unless your surname is Wong, because the other name is Wong Kit Chun. Okay, so, but in Wishing Long Hong, Court of Final Appeal reduced the damages by 20% because the employee, even though he fell down because he couldn't see where he's going, was partially at fault. I mean, you're walking along, hiking along a trail with steep falls on one side. You should be walking rather carefully. Or in fact, if I was that employee, I would have insisted on having a torch. Okay. By the way, if you are hiking, everybody, be careful, all right? I hiked yesterday from Tung Chung to Moi Wau and to Discovery Bay. Oh my goodness. Okay. So there you are. Hiking's good. But, I mean, watch out if you're taking selfies on a hike. I mean, these silly people go, oh, let's go to the edge of the cliff. Oh, I want to do a selfie. Oh, bang, goodbye. Be careful. Okay. Don't force the emergency services to come and try and rescue you, like they did with me back in 2012. Anyway, so Wishing Long Hong, good case, 20% reduction. In the Reeves case, the suicide case, contributory negligence, 50%. Well, that's the decision of the court. Could have been 60%, could have been 70%, who knows? Badger is my favourite case because that's the smoker case. And remember, in Badger, the plaintiff died from lung cancer, but the lung cancer was partially caused by the asbestos fibres that he inhaled during his work. Okay, he was advised about this, so there was evidence that the victim, was asked to give up smoking. Hang on, you might get lung cancer, but he was so addicted to tobacco, could not reasonably have been expected to have stopped smoking. And the court held that had he been guilty of fault, he was partially at fault, okay, because he should have given up the smoking. All right, so the reduction of damages was just and equitable on the circumstances because of the relative blameworthiness of the smoker. So the court reduced his damages by 20% because he was a smoker. But he had died, so it wasn't him, it was his personal representatives who were suing on behalf of his estate. Okay, so the contribution to the combined risk of his continued smoking when he should have stopped was held in the region of half of his ultimate risk. So the appropriate reduction was 20%. Anyway, so that's the Badger case. Nettleship and Western, our good friend. In Nettleship and Western, remember, Valentine did not succeed as a defence because it was a vehicle on the road. But in Nettleship and Western, the court found the driving instructor was partially at fault. 50%. Okay. Could have been 60, could have been 70, could have been 20, and that was the decision of the court. Stapley is a rather tough case as far as the result is concerned. On page 133, in Stapley, the damages were reduced by 80%, which is extraordinary. That's really up near the top end, okay? And in Harrison, they were reduced by 20%. So Harrison's on page 133, yeah? And, certainly Stapley's on 133. Yeah, Harrison's right up the top. Harrison and the British Railways Board. Plaintiff was a guard who was injured, tried to assist the defendant passenger getting on a moving train. Well, he was partially at fault, so he was injured, but his damages were reduced 20%, so that's Harrison. So again, in fact, I've got the next PowerPoint, summarising the apportionment aspect. Remember, it's up to the court on the facts of each case, as the court thinks just and equitable. And Young and Lee does say that previous cases are only a guide. Okay, that's on page 137. So worth noting the attitude of the courts in Hong Kong to contributory negligence, and the final reduction is always up to the court on the facts of that particular case. All right, and the seatbelt cases, though, I think you can safely advise any person you're advising where you have a plaintiff not wearing a seatbelt who's injured, that the damages will be reduced between 15 and 25%. Ho Wing Chun, you can cite, okay? Cannot see any word due to small. PC cannot hear anything first, so I log in 2 times in this lesson. Thank you for your help. All right. I'm not sure. Okay. Well, okay. Oh, by the way, everybody, this lesson is being recorded, so presumably the recording is going well, so you can always listen again. Isn't that exciting? All right. Don't forget, everybody, the burden of proving any defence is on the defendant, and similarly with contributory negligence. Okay. So. Also, I threw in a sort of an extra one. You could get an extra 1 or 2 marks in an exam question if it's relevant. Remember, under the limitation ordinance, the limitation period for personal injury cases is 3 years, but there's quite a lot of scope in the legislation for extending that time period, particularly under Section 30 of the limitation ordinance. Worth knowing, I mean, should know, not must know. Okay, so that's it for defences, everybody. Now let's get on to private nuisance. And let me know, just give me 1 second while I switch the PowerPoints. Okay, on to private nuisance now, and of course we did cover this last time. So, the first PowerPoint is quite a good one. This is the overview. So this is where I say, put on your seatbelts. The helicopter is taking off. We're up in the skies looking down. So we're looking at overview of private nuisance. First thing, everybody, with regard to private nuisance is must know the definition of private nuisance. It's sort of on the screen, but I think probably a neater definition would be private nuisance is unreasonable interference. Unreasonable interference with the use and enjoyment of the plaintiff's land. Full stop. That's it. That would do. Okay? So that's private nuisance. Must know definition. And in the assignment question 2, it is on private nuisance. So write down the definitions. The definition. And then, of course, use your definition to identify issues. Of course, what is unreasonable interference? Obviously, is a big issue. And of course, it depends on the type of damage suffered by the plaintiff's land. If there's actually physical damage, that implies unreasonable interference. Without further ado, St. Helens Smelting and Tipping, and in Hong Kong, ACL and Bulmer on page 97. Must know case, the Bulmer case. So if there's physical damage to the plaintiff's land, that's unreasonable interference, full stop. Okay. However, if there's less tangible interference, and this will depend on what the type of nuisance is. Is it noise? Is it smells, smoke, vibration, etc.? Well, then the court will have to look at a range of factors to consider whether the interference is unreasonable. So we'll be looking at, well, let's have a look at reasonable user now. So with regard to actual material damage to the plaintiff's land, that's St. Helens Smelting and Tipping and Bulmer, which we've already covered. With regard to, if you like, personal discomfort or less tangible interference, I like that word, discomfort. How comfortable are you? Oh my goodness. Okay, so capital, prosperous and sheen, must know case, capital, prosperous and sheen on page 100 of the course manual. Remember, how many showers a day do you have? Well, if you're having a shower late at night, this is a case which you might think of. And in capital, prosperous and sheen, it was somebody operating a water pump. They did say after 11 p.m. in your course manual. I think it's pretty close to midnight. And the sound of the water pump kept the neighbour awake, because I mean, these water pumps do make rather awful noises, I must say. And so the neighbour sued for in private nuisance. Was that unreasonable interference with the plaintiff's use or enjoyment of land? Well, was it unreasonable, particularly with regard to timing? And the court said no, because people in Hong Kong go to bed late. Probably because there's so many lights in Hong Kong. I don't know. And it was not unreasonable for somebody to have a shower near midnight. Okay. The fact that the plaintiff himself liked to go to bed early really doesn't make any difference. Why did the plaintiff want to go to bed early? Well, because he had to get up very early the next morning. Okay, so the court said that they did not see anything up to midnight could be regarded as out of the ordinary. Okay, so there you are. Capital, prosperous and sheen, must know case. It's a case on the factors the court will take into account, particularly the factor of timing. Okay. Also, you could argue, if you look at the last bullet point, everybody, the court will look at abnormal sensitivity. Could you argue in capital, prosperous and sheen that the plaintiff was abnormally sensitive? Yes, you could. That would be an overlapping factor in capital, prosperous, and sheen. Also, locality is very important. The so-called locality principle, as mentioned in the case of Sturgis and Bridgman, where they said whether anything is a nuisance or not is a question to be determined not merely by the abstract consideration of the thing itself, but in reference to its circumstances. What would be a nuisance in Belgrave Square, which would, in Hong Kong, what would that be? The peak, fancy area of Hong Kong, would not necessarily be so in Bermondsey, well, a less salubrious area. Okay. Oh yeah, actually they do mention, I'm sorry, I always forget this. In Hong Kong, they do mention what would be a nuisance in a low-rise residential area on the peak would not be a nuisance in an industrial area in Shun Wan. Oh dear. We shouldn't get into classifications of areas in Hong Kong, but that's what the court will have to do. Okay, so obviously the locality principle applies here, but there are limits as illustrated in the Realty Harvest and Gold Margin Development case. Just remember it as the Realty Harvest case, in which the area involved was in it was in an industrial building in Shun Wan. So you've got to expect noise and vibrations to be pretty high there, but the noise and vibrations were unreasonable. It is a question of degree with reference to the facts of each case. So that's Realty Harvest with regard to locality. Also, another factor the court will look at is the defendant's response to the plaintiff's behaviour. This is under the heading in your course manual of malice on page 100. What do you mean by malice? Malice means bad thoughts, okay, or bad intentions. Another way of saying the same thing would be anti-social activity. So you're acting in a way which is anti-social. And this is what happened in the two cases there, Christie and Davey, Hollywood, Silver, Fox Farms and Emmett. They're the English cases. And also in the Hong Kong case of Chan and Thomas, which is on page 101. So in Christie, remember, it was the plaintiff was a piano teacher who gave piano lessons at her home. The defendant was the neighbour, found the noise during these lessons annoying, and in order to sort of express his annoyance or get rid of his tension, I suppose, the defendant deliberately created noise in retaliation. Well, this was not reasonable. So the plaintiff sued the defendant for nuisance, and in entering judgment in favour of the plaintiff, the judge said, what was done by the defendant was done only for the purpose of annoyance. It was anti-social activity, it was malicious, and in my opinion was not a legitimate use of the defendant's house. And also is in retaliation. Well, this was not reasonable. So the plaintiff sued the defendant for nuisance, and in entering judgment in favour of the plaintiff, the judge said, what was done by the defendant was done only for the purpose of annoyance. It was anti-social activity, it was malicious, and in my opinion was not a legitimate use of the defendant's house. And also Hollywood, Silver, Fox Farms, this was the somebody who out of malice fired guns on his own land to make sure that the foxes next door would not produce cubs or that were killed. The foxes, yeah, affected the foxes. And the court granted an injunction preventing the defendant's otherwise legitimate conduct. It was legitimate to fire a gun, but he did so, again, it was anti-social activity out of malice because he was anti-fox breeding, okay, which is, some people say, hang on, isn't that nice? Protect the foxes, kill the chickens and all the rest. I don't know. So that's that case. And of course the Chan and Thomas is the Hong Kong case where the insertion of a grill in a drain moved the risk of flood to the neighbouring property. The court found this was antisocial or malicious behaviour, and it was unreasonable. Okay. And interesting to note, and we'll look at this in a moment, the remedy for private nuisance will be an injunction. And then last but not least, abnormal sensitivity. The must-know case, I think, is Robinson and Kilvert, but also the Sheen case, as I mentioned before, is an example of the plaintiff having, if you like, abnormal sensitivity. So in the Capital Prosperous and Sheen case, the plaintiff was abnormally sensitive because most people don't go to bed so early. Okay. Also, so an ordinary person in Hong Kong doesn't go to bed at 8:30 at night, that sort of thing. And Robinson and Kilvert, the defendant operated a business that required hot, dry air. The temperature of the floor of the plaintiff's premises was consistently above 80 degrees Fahrenheit. This damaged heat-sensitive paper, and the court said, bad luck, this was not unreasonable interference because the heat would not have damaged ordinary paper. So you are judged, the plaintiff will be judged for that of a, if you like, an ordinary person. In this case, it was the material was heat-sensitive paper, which was damaged by this particular heat, but ordinary paper would not have been affected. Okay, so the Court of Appeal rejected the plaintiff's claim based on nuisance and held that no actionable nuisance was proved. Robinson and Kilvert, must-know case, everybody, and in Sheen, of course, abnormal sensitivity. The court, because the court will, remember, they're looking to see whether the interference is unreasonable. Also, there's an interesting case on the page 102. Those of you who are into electric guitars, this is the Morris case, Network Railway Infrastructure and Morris. Okay, and the plaintiff operated a music recording studio, and the plaintiff brought an action against the defendant claiming the nuisance on the ground that a section of the railway's signalling system produced electromagnetic interference with these electric guitars, which were placed on the studio. So instead of rejecting the claim on the grounds that the plaintiff was extraordinarily sensitive, the court recognized that the use of electric and electronic equipment was now common. Okay, so he was not unusually sensitive, abnormally sensitive. And of course, we all use electronic gear like we're using at the moment. Okay, you know, Adobe Connect with abnormal sensitivity with regard to sound in particular. Oh my goodness. Okay, so the Court of Appeal held focus should be on what was reasonable in the circumstances and whether the damage was too remote. So the interference with the electric guitars was not abnormally sensitive. So there you are. Good case, Morris. Those of you into electric guitars, if you're listening to music. Okay. Well, there you are. Okay, so this is as far as we got last time. Now, next big issue with private nuisance. Who can sue? Now, in order to understand this, don't forget the definition of private nuisance. Unreasonable interference with the use and enjoyment of the plaintiff's land. Emphasize the word land. So, the case of Malone and Lasky, which is must know on page 103, is the leading case, confirmed by the House of Lords much more recently in Hunter and Canary Wharf. And what those two cases lay down is that only a person with a legal interest in the land can sue in private nuisance. I'll say again, only a person with a legal interest in the land can sue in private nuisance. And this is where you do need to have an elementary knowledge of land law. Okay, and I will, in the next couple of PowerPoints, explain who does have interest in the land. In particular, the distinction between somebody who has a lease and somebody who has a license. A lease is land, a license is not land. A lease is a right in rem, the Latin expression. A license is a right in personam. Only a person who has a right, a legal interest in the land can sue in private nuisance. So normally it's only somebody who has a lease. So if somebody owns a flat in Hong Kong, yes, you can sue in private nuisance. If you rent a flat in Hong Kong, yes, you can sue in private nuisance. But if you only have a license to be on premises, what is a license? It's simply a right to be on premises. You've got permission of the owner. And that means that your presence on the property is legal and you are a visitor as opposed to a trespasser. Okay? So if you're a guest staying at somebody's house, you can sue in private nuisance. Okay, so that's Malone and Lasky. Very old case, way back in the early 20th century, but more recently confirmed by the House of Lords in Hunter and Canary Wharf. Hunter and Canary Wharf is a leading case on private nuisance. Okay. Now, in the middle of both Malone and Lasky and Hunter, I've got a case called Coruscant and Bush. Now, Coruscant and Bush, everybody might like to know. It's not must know. It's not should know. It's might like to know. I like mentioning the facts of this, though, and it's not in your course manual either. So, but let's go through it. What happened in Coruscant and Bush, because the facts are sort of interesting. It was a young lady who was staying at home with her parents. You'll notice the year 1993, before mobile phones, before smartphones. And so if you want to ring somebody, telephone somebody, then, you know, you had a landline. And with landlines, you don't know who's calling until you pick up the phone. So what happened was that the young lady had a boyfriend and they had a falling out, but the boyfriend wasn't giving up. So he kept making calls to his former, well, she thought it was former girlfriend. And it was this private nuisance. So the young lady sued the boyfriend for private nuisance. And in the English Court of Appeal, I emphasize Court of Appeal, okay, the court said yes, she could sue, even though she didn't have a legal interest in the land, as long as there's a substantial link between the plaintiff and the effective land. But that has now gone, okay? By the way, the Court of Appeal in Hunter followed Coruscant and Bush, but now we've got the House of Lords in Hunter and Canary Wharf, and Hunter and Canary Wharf, as I say, is the leading case, 1997, in which the court's saying, no, 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 Malone and Lasky is the law. Only a person with the legal interest in the land can sue in private nuisance. So there you are. It's interesting that Coruscant and Bush would not happen these days, would it? Because somebody calls you on your phone, be your smartphone usually, you know who's calling. Okay. Well, unless, well, you sometimes you don't, but certainly you would know if that person has called you before. If you've got a new number, well, you wouldn't know. Okay, so there you are, Hunter and Canary Wharf. That confirms Malone and Lasky. Only those with the legal interest in land can sue in private nuisance. Now, what is a legal interest in land? Well, on the screen I've got only those who are freeholders. What is freehold? Freehold title means the property is yours forever. The legal expression is in perpetuity. In Hong Kong, by the way, no land is freehold except St. John's Cathedral. All the land in Hong Kong is leasehold. So the government is the landlord, and the government is in charge of distributing, if you like, government leases. And normally a government lease is issued subject to conditions, normally conditions of sale, and then normally a developer then granted the government lease, and then whacks up a multi-story building and then sells off all the individual flats, okay? And the people who buy the individual flats or units in a multi-story building, they actually are tenants. The government is the landlord, okay? And I'll explain this in a moment, the next PowerPoint or two. Okay, so forget about freeholders in Hong Kong. There are no freeholders in Hong Kong, but there are tenants. A tenant is somebody who has a lease. The legal terms for a lease well, there's more than one word for a lease. can be a tenancy agreement, okay, can be a demise, because the lease has been around for a long, long time. Originally, a lease was just an agreement between a landlord, because in England all the lords own the land, and what they did initially is they allowed the poorer people, the commoners, to work the land to grow fruit and vegetables, etc., because people have to eat. And so the people who were given permission to use the land of the Lord were called tenant farmers. Okay, and then the tenant farmer. So there was just an agreement between the landlord and tenant. But it soon became obvious to the tenant farmer that it's pretty useless having this land to grow fruits and vegetables if everybody in the whole world can walk across my fields. So by necessity, the tenant farmer was given exclusive possession of the property. And that's the hallmark of a lease. If you have exclusive possession of the property, then your right is more in the nature of land or a right in rem than just a personal right. So what is exclusive possession? Well, coming up, we'll have a look at that in a moment. So a tenant, now in Hunter, Lord Gough, bless his heart, says also licensees with exclusive possession. I've got question mark there because if you have exclusive possession, 99.999% of the time, you have a lease. Okay. Okay. So there you are, only a person with the right in land. Mere licensees cannot claim. Mere licensees cannot claim. And with some interesting cases on this, first of all, and Yung, which is on page 103. Now, everybody, you think tort law is a bit dry and uninteresting. Look at the facts of and Yung. It was a dispute between two roommates in a residence hall at Chinese University. So the plaintiff sued the defendant in nuisance. So there's a claim in private nuisance, claiming what was he claiming for? That the defendants engaged in sexual intercourse with a boyfriend in the presence of the plaintiff. My goodness, that's an interesting type of private nuisance. Went on to the Court of Appeal. They held that. I bet they were, the judges were sort of, hello, what's going on here? That would have brightened up their lives a little bit. But the whole action failed because the plaintiff did not have an interest in the land. He was only a licensee. Okay, so what's the difference between a lease and a license? Coming up. Also, Artco Properties on page 103 as well. You got the facts there, but basically it boils down to the fact that the plaintiff did not have an interest in the land. Okay, all right. By the way, what was Hunter all about? Hunter concerned, this is on page 103 as well. In Hunter, the plaintiffs were a group of residents, including owners, tenants, and licensee. The complaint was that there was a 250-metre metallic facade of the Canary Wharf Tower building, and you know when the sun was reflected off that, it was very glary, but it also affected their television reception of the residential premises in the neighbourhood. So this was interference with TV reception. Could this ground a claim in private nuisance? Okay, well, was this related to the land? Okay, because what is private nuisance? Unreasonable interference with the use and enjoyment of the plaintiff's land. So, what about watching TV? Well, interesting quotation from Hunter was that the court said that for many people, watching TV transcends the function of mere entertainment. So, I mean, this is before the internet, isn't it? Now, even more so because, you know, if you're watching on your laptop, you're not just there for entertainment, you're there for information. You're there for what, like you people are on your PCs, okay? It's not just there for entertainment. So it was related to the land, so that was interesting. Watching TV was, you know, relating to the use of the land. But they found on the facts there was no private nuisance in Hunter because the mere presence of a building was not sufficient for private nuisance. you need something to emanate or come out of the building to ground a claim in private nuisance. Although there's an interesting case in New Zealand in which the dazzling glare from a glass building was held to be private nuisance. For those of you interested, the case name is Bank of New Zealand and Greenwood. Oh my goodness, yes. Not me, I'm Australian. Well, I was. I'm Hong Kongian now. Okay. So there you are. Hunter, that were the facts of Hunter. There was a claim that the simply erecting a building was sufficient to ground a claim for private nuisance, and because it interfered with the TV reception, the court said, well, TV reception is connected with the land, but you need something to emanate from the land. And in Hunter and Canary Wharf, there was nothing emanating from the land, but in that New Zealand case, there was a dazzling glare from the glass. Okay, so the court said that was private nuisance. So I guess you'd have to do something to reduce the glare. Okay, so that's interesting cases on who can sue. What are the must-know cases? Malone and Lasky says only a person with the legal interest in land can sue in private nuisance. But Malone and Lasky is a pretty old case. Is that still good law today? Yes, it is, because it's confirmed by the House of Lords in Hunter and Canary Wharf. Only those persons with a legal interest in land can sue. And in Hong Kong, that would be either the owner of the unit or the tenant, who may have a tenancy agreement or a lease. Okay, but if you're merely a licensee, somebody is on the property with permission, which turns your presence into that of a visitor rather than a trespasser, you cannot claim in private nuisance. So that's why in and Yung, the person who wanted to sue for private nuisance because of the noisy sex, they couldn't do so because they didn't have locus standi, is the legal expression. They couldn't sue because they did not have an interest in land. Okay, everybody. So that's pretty good. We've covered quite a lot on private nuisance already, but I think it's a good time to have a break. So we'll have our 10-minute break now, and then after the break, we'll come back and finish off private nuisance. And I will also be, sorry, I don't know what I did there. We'll talking to you about the assignment. So I'll put a little note on the chat box here. Where are you? Come in here, yes. Okay, everybody, welcome back. So the chat box is ready to go again. So we shall be finishing off private nuisance. And then I will take you through some pointers about the assignment, because question 2 of the assignment is on private nuisance. Okay? All right, so before the break, we were looking at what private nuisance is. You know the definition, don't you? Private nuisance is unreasonable interference with the use and enjoyment of the plaintiff's land, with the emphasis on land. Okay, so the focus is on the effect on the plaintiff's land, and of course, you cannot sue in private nuisance unless you own land, unless you have a legal interest in the land. So I'm going to talk a little bit about sort of land law, basically, about who can sue. And remember, it's only those persons who are, in common parlance, the landlord or the tenant, only those persons who can sue. If you're a mere licensee, as I am in room 306 of Admiralty Centre at the moment, I am here legally, but I only have a license. And so my right is only a right in personam, only a personal right. It's not a right in land. A lease is a right in land. Okay. Here we are. Which chapter I need to be concerned about an assignment question? Well, I'm going to talk about the assignment in a moment, but with regard to the contract question, which is question 1, obviously that's chapter 1, I think, isn't it, of the book, dealing with the elements in the formation of a contract, particularly the element of agreement. Okay, and with regard to question 2, it's private nuisance, so it's what we're talking about right now. Okay, so there you are. Let's get on to a little bit of land law here, because what is a lease? A lease, everybody, there is a definition of a lease. Obviously, this is land law, not for our purposes, but a lease is accommodation granted for a term at a rent with exclusive possession. So that's the definition of a lease. And a lease is land. It's what we call a proprietary right. Or another way of saying the same thing, it's a right in rem, in the thing, as opposed to a right in personam, which is just a personal right. So a lease is a right in land, a license is not. Now, what do you mean then? Of course, accommodation, you know what accommodation is. Granted for a term. Term means it could be any length of time at a rent. And but what is exclusive possession? That's the hallmark of a lease. What is exclusive possession? EP. Exclusive possession is you ask the question, does the occupier have the right to exclude the world at large? Or in other words, nobody can be on the property without your permission. You have control and dominion over the property. Okay. Well, I don't have exclusive possession of room 306 in Admiralty Centre. Anybody can enter this lecture room at the moment. I can't stop them. Okay. If I did own room 306 in Admiralty Centre, if somebody were to knock on the door, can I come in? I can say, no, go away. Don't want you. You have control and dominion over the premises. Nobody can be on your property without your permission. Okay? Okay, good. How do we make sure our attendance is being recorded? I don't know, actually. Well, there is a list of attendees, so this is being recorded. So presumably all the list of attendees would be sufficient. Okay? I don't. You have to take that up with space. Yeah, because our lessons have largely been online. I'm not sure how they keep the attendance. Okay, all right. So that's it. So that's exclusive possession. And if you do have exclusive possession of property, there is, I say, there's a technical argument. It's possible to have exclusive possession of a property without having a lease. It's possible you could have exclusive possession because you don't pay rent, for example, for some reason. But normally, if you have exclusive possession, you have a lease, okay? And that means that's a proprietary right, a right in land, a right in rem. And you would have the right to sue in private nuisance. Okay? If you only have a personal right, that is not a right in land, that's only a right in personam. You do not have an interest in the land, you cannot sue in private nuisance. So if you are on land legally, then you would have a license. A license is merely a permission to be there. Okay? All right, so that's that. And I've also, for those of you interested, I'm sort of straying a little bit perhaps, you might argue too far, but not that much, into land law. But I've also got the next PowerPoint on land ownership in Hong Kong. You might be interested because, you know, most people in Hong Kong aspire to own their own property, which would mean generally a unit in a multi-story building. So if you buy a unit in a multi-story building in Hong Kong, what legal rights do you acquire? Well, every piece of land in Hong Kong is subject to a government lease. And if there's a building on it, then you are, the government lease would cover the building and the land on it. And if you buy a unit in a multi-story building, the rights in land that you get is that you are a co-owner of the land and the building on it. And the form of co-ownership is what we call a tenancy in common. What is a tenancy in common? It's a form of co-ownership that gives the holder an undivided share in the property. Undivided share in the property. And how big is your share normally depends on how big your flat is. So if your flat is twice as big as your neighbor, then you have twice as big a share in the property, which is interesting because I own my flat in Tung Chung, yes, 35-story building, except there's no 14th or 4th floor, you know what I mean? No 24th floor, because number 4 is unlucky. Anyway, a roughly 30-story building in Tung Chung. And I can honestly say I co-own the whole building and the land on it. So it's somebody from outside Hong Kong, what? You co-own the building and the land on it? My goodness, you must be rich. Well, not that. Because, you know, I share it with 1,000 other people, or what, I'm not sure how many other units there are in the whole building anyway. So there you are. So I have a tenancy in common of the rest of the government lease. That's called the residue of the government lease. Now, in my property in Tung Chung, the government lease was issued in 1998 for a period of 50 years, so it expires in the year 2048. So if I were to sell my unit today, the person who buys it would have a tenancy in common of the residue of the government lease, and the government lease, how many years left? Oh my goodness, you take 21, 27 years remaining. Okay. You might say, well, what happens when the government lease runs out in the year 2048 in my case? Well, the answer is under the basic law, Article 123, the leases will be renewed, probably for another 50 years. Okay. By the way, you might ask, why is it 50 years, not longer? Well, in Hong Kong, originally, the British, in 1841, whenever they took over Hong Kong, decided they wanted to make the Hong Kong government self-financing. So they said, we will not grant freehold property in Hong Kong, we'll only grant leasehold property. So the initial government lease, called a Crown lease, was for 75 years. But then the Hong Kong people said, you British are a bit stingy. No, so the British came back and said, all right, 99 years, go away. And then said, no, you're still a bit stingy. So the British government, well, basically British government in the Hong Kong government, said, all right, 999 years, go away. So the Hong Kong Club building in Central is on a 999-year lease, okay? But my lease is only 50 years because of Margaret Thatcher and Deng Xiaoping's negotiations. Okay. I mean, they could have made at least 100 years. Why only 50? Anyway, so that's the land holding in Hong Kong. So if you buy a unit in a multi-story building, you obtain the residue of the government lease, and you co-own the whole building and the land on it, and the form of co-ownership is a tenancy in common. A tenancy in common is the form of co-ownership which gives the holder an undivided share in the property. And how big is your share depends on the size of your flat. Okay. which is interesting because when I bought my flat, I was still married, my wife was still alive, and we bought it together. So she said, so we own our flat now? Yes, dear. Well, why are we paying rent to the government? Good question. Because the government is the landlord. So every unit owner in Hong Kong pays rent to the Hong Kong government. That's what the British set up to make the Hong Kong government self-financing. So there you are. That's not bad, is it? So how many units in a multi-story building in Hong Kong are there? Well, God knows, I don't know. I pay, how much do I pay? I don't know, $6,000 a year or something. But yeah, every unit owner pays a certain amount of money to the Hong Kong government. That's why they should have lots of money to give back to us. Anyway, so there you are. That's the land ownership in Hong Kong. So those of you who are aspiring to buy a unit in a multi-story building in Hong Kong, you obtain the residue of the government lease and you co-own the building and the land on it. In the form of co-ownership is a tenancy in common. Okay, and you do pay rent to the government. Okay, so there you are. So a person who owns a unit in a multi-story building has an interest in land, so you can sue in private nuisance. And if you rent out your flat, and technically if you rent out your flat in Hong Kong, the person who occupies it will be a subtenant. Well, they would have an interest in land as well. Okay, so they could sue in private nuisance. Okay, so there you are. Remember, for private nuisance, only those persons who have a legal interest in the land can sue. Okay, so there you are. That's the mini lecture in land law, which I trust you find interesting. Should know, I wouldn't say this is must know, but obviously important in practice. Clearly, only those persons who have an interest in land can sue in private nuisance, but who can be sued? Who is liable? Well, obviously the creator of the nuisance. So this is covered in your course manual on page 104 onwards. The creator of the nuisance should be liable in nuisance claims. So normally that's no problem. It gets a little bit tricky when you have an owner who rents out the property. So who are you going to sue? Do you sue the owner of the property or do you sue the tenant? Okay. Well, normally it's the occupier of the premises will be the creator of the nuisance, so you sue the occupier. Basically, that's it. It gets a little bit complicated, though, sometimes when you have slightly different landlord-tenant relationships. But if the landlord is the occupier, then obviously they will be liable for private nuisance. But if the landlord has rented the land to a tenant, and under the tenancy is the tenant who has the exclusive possession of the land, well, obviously, they would be the person who would be liable to be sued in private nuisance. Okay, so who has exclusive possession of the property? They are the person who you would actually sue. Okay, and you've got there's a pretty good discussion in your course manual on pages 105, 6, 7, I think. Yes. Okay. So that's pretty well it. Normally that's not an issue in exam questions. It's very clear in exam questions. Who is the person you're going to sue? It will be the person who creates the nuisance. Okay. And then defences to private nuisance. And the defences to private nuisance in your course manual come after their discussion of public nuisance. So we're on page 113 of the course manual. And everybody, as far as defences are concerned to private nuisance, the most important defence, as it says on the screen, is that of statutory authority. So if somebody is doing work on their property, which might otherwise be a private nuisance, then that person may rely on the defence of statutory authority. And probably the leading case in Hong Kong is Lam Yuk Fung and the Attorney General of Hong Kong. And the test here is the activity which has been authorised by the legislation, is it the unavoidable consequence of doing what they're being authorised to do, well, in that case, then that's a total defence. But in Lam Yuk Fung, which is on page 114, the defence failed. It was Lam Yuk Fung suing the Attorney General of Hong Kong. The plaintiff's commercial premises were next to a refuse collection point. Well, obviously, there would be nuisance with noise and all the rest, okay? Not noise, smell, sorry. Operated by the Urban Council. Well, obviously, I don't think we have urban councils anymore, do we? They're district councils, but they were called urban councils then. So the urban council was authorised to run these refuse collection points. So obviously there's going to be some sort of nasty smell coming from it with all the rubbish. But the plaintiff brought an action against the council claiming that the refuse collection point constituted nuisance. Why? Because the rubbish was sort of all over the place. There was no system in place. And the council could have done more. They could have avoided the nuisance with exercise of reasonable care. They could have organised the collection in a more reasonable fashion. I mean, it does depend on the facts of each case, all right? So I think is what happens, that people were just dumping their rubbish all over the place. So there should have been a much better system for collecting this rubbish and then processing it. So in Lam Yuk Fung, Attorney General of Hong Kong, the defence of statutory authority failed, okay? The defendant could have avoided the nuisance through exercise of reasonable care. And the noise or the nuisance, you know, all the rubbish all over the place with the awful smell, was not the unavoidable or inevitable consequence of what the legislation had authorised the council to do. So that's the test. So if you've got statutory authority, then that is a total defence. Similar to statutory authority will be planning permission, okay, which we don't need to worry about. There's also another defence. The awful smell was not the unavoidable or inevitable consequence of what the legislation had authorised the council to do. So that's the test. So if you've got statutory authority, then that is a total defence. Similar to statutory authority will be planning permission, okay, which we don't need to worry about. There's also another defence called coming to the nuisance, which again, that used to be a defence but is no longer a defence, and that if you're buying property which already has, you know, next to something which has a smell or something or other, then that could be a defence. But normally that's not so important. I've also mentioned section 21 of LARCO there, but it's very hard. Contributory negligence. Remember in Chan and Thomas, there was an insertion of a grill to make sure any flood nuisance the risk was passed to the neighbour. So the neighbour's property was flooded. Was the neighbour under an obligation to clean up the mess created by the neighbour? The court said no, okay. So contributory negligence is not a defence really to private nuisance. And then we have other defences which are sort of interesting. Act of stranger, act of God. First of all, act of stranger or trespasser, not under the control of the occupier, that could be a defence. That's the ideal consolidators case. I'm not sure that's actually in your course manual anyway. That's not a very important case, but anyway. What might be important is number 5, act of God. Now this is a slightly interesting case because normally some sort of natural occurrence would not be a defence. But in the Star Ferry case, there was an act of God which was totally unforeseen and could not, by the exercise of all reasonable care and skill, have been avoided, because what happened in the Star Ferry case, it's actually a public nuisance case, but as far as the defence is concerned, it's was a total defence. And we're going to deal with public nuisance later, but anyway, in the Star Ferry case, the ship was blown off its anchors and damaged the Star Ferry pier. So the Star Ferry company were not very happy, so they sued. It's actually a public nuisance. But anyway, the question was there the total defence of act of God? And the court said yes, because that particular storm was unprecedented. It was totally unforeseen. It was something overwhelming. And so the defence of act of God was a successful and total defence, even though it was a natural occurrence. I mean, I haven't been on the Star Ferry for a while, but it's always a pleasant trip across the harbour because it's much shorter than it used to be because of reclamation. But there you go, Star Ferry, one of Hong Kong's famous tourist attractions. Still is, okay, it's always good to be on the Star Ferry. Get out your cameras, but be careful, don't fall overboard. Okay, so there you are, Star Ferry case. I'd say must know, could come up, has come up in past exam papers, probably in part A of the exam as a 10-mark type question, half a question. Explain the defence of act of God in relation to private and public nuisance. Okay. What about now remedies for private nuisance? Well, the main remedy, actually, I've got these around the wrong way, really. The main remedy is an injunction. Okay, because if somebody's creating a nuisance, you want it to stop. So you go to court, and inequity, remember, from our contract law, inequity, the two major remedies, which are in the form of a court order, will be either an injunction or specific performance. The relative remedy here is an injunction, and it would be a prohibitive injunction to stop the activity going on. And because we are in equity, the equitable maxims apply. So if you are suing in private nuisance, and indeed public nuisance, we'll have a look later, don't delay. Delay defeats equity. Also, he who seeks equity must do equity, the clean hands doctrine. Okay? And so usually an injunction is the most desirable remedy. You want the damn thing to stop. Okay? But remember, there are two types of nuisance. One is where there's actually property damage to the plaintiff's land, and the other one where there's sort of intangible interference. So with regard to intangible interference, in other words, no property damage, the most suitable remedy would be an injunction. That's all you want. But if there's actually physical damage to the property, so I'm going up to the top PowerPoint now, then yes, you can sue and get damages, okay, and also any consequent economic loss. Although interesting, you cannot claim damages for personal injury in private nuisance. I'll say that again. You cannot claim damages for personal injury in private nuisance. Okay. I'll run a few questions by you, everybody, just for the moment. Can you claim damages for personal injury, in negligence? The answer is yes. Okay. Can you claim damages for personal injury in private nuisance? The answer is no. Can you claim damages for personal injury in public nuisance? The answer, everybody, as we will find out later, is yes, you can. Seems a bit odd. You can claim damages for personal injury in public nuisance, but not private nuisance. The answer will become clear when we get to public nuisance later on. But remember what private nuisance is. It's unreasonable interference with the use and enjoyment of the plaintiff's land. It's the effect on the land, not the person, if you like. So if you want to claim damages for personal injury, you sue either in negligence or perhaps, as we'll see later, public nuisance, but not private nuisance. Okay? And Hunter is a case that says that, Hunter and Canary Wharf. There's another case, English one, which we don't need to worry too much about, Corby, which says the same thing. Okay, so that's an important point to make. In your assignment question 2, I don't think anybody's actually suffered personal injury. So but there would be either property damage or there could be intangible interference. Okay, so remember, the most common remedy for private nuisance will be an injunction. Okay, so that's the important point to make. If there is actually property damage, though, you can get damages for the physical damage to your property and any consequent loss. And in the case of Wong and Liu on page, I think it's 117, let me just check, where's Wong and Liu? Yeah, Wong and Liu on page 117. Your course manual does mention this case, top of page 117, Wong Siu Hong and Liu Q, whether I pronounced that right. There was compensation for consequent loss as a result of damage to property. The amount of money, everybody, for interest sake, is $176,500. So $176,500 in the Wong and Liu case. So there you are. That's a substantial sum of money. Okay, but if there's only intangible interference, then your only remedy would be an injunction, and that would be the most desirable remedy because you want the activity to stop. You don't want to be hassled by that nuisance. Okay, all right. So there you are. They're the two remedies for private nuisance. Most commonly, an injunction, typically where the interference is intangible interference, and maybe less commonly damages if there's actually physical damage to the property and also any consequent economic loss, but not personal injury damages. So if you suffer personal injury, the suitable tort to sue in will be negligence and possibly public nuisance. All right, and we'll be talking about public nuisance a little bit later on today, but we won't finish off public nuisance. Now, just before we leave private nuisance, I want to talk a little bit about, this is more should know, not must know. There is a tort called Rylance and Fletcher. Now, Rylance and Fletcher is actually mentioned in your course manual way back on page 13, subpsalm. Okay, so if you go to page 13 of your course manual, halfway down it says the rule in Rylance and Fletcher. Now, Rylance and Fletcher, we'll look at the facts of the case in a moment, is a form of nuisance, okay? But it's a form of strict liability nuisance. And there's actually a separate tort called the tort of Rylance and Fletcher. It sounds a bit funny, you name a tort after a case. But it is a subspecies of nuisance, okay? And if certain facts occur, then there's no need to show fault on behalf of the defendant, okay? Again, you've got to have an interest in land to sue, so that's why it's similar to private nuisance. So what happened in Rylance and Fletcher, the facts are there on page 13. The defendant was the owner of a mill. In order to improve the water supply to the mill, the defendant hired contractors to build a reservoir on the defendant's land to supply water to the mill. Fair enough. Okay. During the construction of the reservoir, the contractors discovered mines and underground passages beneath the defendant's land, but they took no further action. So when the reservoir was finished, the water from the reservoir went into the underground passages and ultimately flooded the plaintiff's coal mine. Okay. So, I mean, it's a sort of a big case, if you like. So the House of Lords cited with approval the ruling of Blackburn says a person who has, for his own purposes, brings onto his land and collects and keeps there anything likely to do mischief if it escapes, must keep it at his peril, and if he does not do so, is prima facie answerable for all the damage which is the natural consequence of its escape. So there's a form of strict liability. Okay. And there have been some rather dramatic cases. There's a case not in your course manual called Reed and Lyons dealing with the munitions factory. The court said the fact that there were munitions on the land, there was a World War II case during wartime, was not unnatural. And there are other cases as well. But Rylance and Fletcher, everybody, is not must know. It's not even should know. It's sort of might like to know. It's a very, very, very narrow tort. It's not actually part of our syllabus, but it is a subspecies of nuisance, so it's worthwhile just mentioning, albeit briefly. How important it is it? Well, there's a fairly recent House of Lords case called Transco and Stockport, which had a look at the rather broader question, should we abolish this tort of Rylance and Fletcher? They said, well, no, I think we should keep it, but only within very narrow boundaries. Okay, all right, so that's now before we leave private nuisance, I thought I'd give you this particular PowerPoint because it sort of draws together our two major torts on our course, which of course negligence and private nuisance. Okay, so what is the sort of like compare and contrast private nuisance and negligence? First of all, with regard to private nuisance, you must have a legal right to sue. Okay, and as by contrast with public nuisance, we haven't got into public nuisance yet, but in public nuisance, you can sue even though you don't own land. That's one big difference between private nuisance and public nuisance. Okay, so negligence focuses on the defendant's conduct, which we've looked at, while nuisance focuses on the effect of the action on the plaintiff's land. Because you know what private nuisance is, don't you? It's unreasonable interference with the use and enjoyment of the plaintiff's land. Must know definition. Okay. There is an academic argument, really, you know, is sort of negligence and private nuisance, are they sort of coming into it, sort of overlapping? Because unreasonable interference does seem to hint at some degree of fault creeping into nuisance and increasing the overlap with negligence. So that's a bit of an academic argument. One big difference, though, between private nuisance and negligence is you can sue for damages for personal injury in negligence, but you cannot sue for damages for personal injury in private nuisance. So that's a big difference. But, you know, that's what's on the screen. Everybody should know, not must know, a bit of an academic argument. Okay, now what I want to do, how are we doing? Getting there, is have a quick word to you about the assignment. Okay, so let me, I've got a special PowerPoint on this. Now let me see if I can access it. Gets a bit tricky with these things. Hello, where is it? Oh, there it is. Okay. That's not what I want. Go away. I don't know what happened. All right, come in again. Good, well done. Okay, assignment. Now I've just got a one-page PowerPoint on the assignment, and a couple of you have been asking repeatedly almost for guidance on the assignment. Well, I've actually given you quite a bit of guidance on the assignment. So let's have a look at your assignment. It's due on the 23rd of March. There are two questions. Question one is a contract law question dealing with the formation of a contract. And as I've mentioned before, start off this way. I'm not sure what the names are, but so-and-so would like to know if there's a contract between him and whoever the other person is, full stop. Next sentence, the court will look for essential elements in the formation of a contract, colon, you know what they are, agreement, consideration, intention to create relations, certainty of form, no illegality, okay, full stop. The next sentence, the only element in issue in question one of your assignment will be the element of agreement. Good. Full stop. You know the next sentence, don't you, everybody? The court will analyze the existence of agreement in terms of offer and acceptance unless there are exceptional circumstances. House of Lords, Gibson and the MCC. Full stop. Next sentence. in your assignment question 1, there are no exceptional circumstances, full stop. So therefore you go on and follow I think it's my last PowerPoint in the very first set of PowerPoints in contract law. Number 1, is there an offer? You've got to be able to define an offer. Has it been communicated to the offeree? Is there acceptance? Has that been communicated to the offeror? Or has the offer been withdrawn before acceptance? So they're the main issues. Okay, so that's question 1 of your assignment. Okay. Now, of course, in the assignment, I'll talk about question 2 in a moment. Question 2, let's talk about now. That's on private nuisance, which you know all about now. So in the question, make sure you tell the examiner, me, what the definition of private nuisance is. You know it, don't you? If you don't, I'll bang my head against the wall and lose more hair. No, unreasonable interference with the use and enjoyment of the plaintiff's land. Always write that down. Then you will have to have a look at, well, is there unreasonable interference? That's obviously going to be the major issue. But the other big issue, of course, will be who can sue. So you'll be given 3 or 4 people, I forget how many, and you have to ask yourself, does that person who may wish to sue in private nuisance have locus standi? In other words, do they have a legal interest in the land? Okay? Assuming they do have a legal interest in the land, well, is the activity they're complaining of unreasonable interference? And that depends on what the interference is. If it causes property damage, remember, St. Helens smelting and tipping plus ACL and Bulmer, that is unreasonable interference. But if it's less tangible interference, how do you know whether it's unreasonable? Well, you've got to go back and look at those factors we looked at before. Timing, duration, the nature of the activity. Is the plaintiff, is there abnormal sensitivity, etc. Okay. Remember, it's up to the court. The court will have to decide whether it is unreasonable interference or not. Okay. Good. So there you are. And then don't forget the remedies, by the way, in question 2 of your assignment. Remember, the major remedies for private nuisance will be an injunction, possibly damages if there is property damage. Okay, good. So that's your question, everybody. Sufficient. All of you now can do both questions in the assignment. So you got over a month to do it. Absolutely no excuse for being late. Okay, absolutely no excuse. All right, so what about the assignment itself? Well, you know when it's due, 23rd of March. And as far as presentation is concerned, highlight your cases and statutes. I don't think there are any statutes in the assignment. No, oh, there might be if there's a. No, I don't think there is. Anyway, but certainly there are plenty of cases, and you should highlight your sources of law, whether it be a case or a statute. And the best way of doing it in the assignment, because you're typing it out, is bold the cases and the statutes. You don't need to do anything else. You don't need to also underline it, etc. All you got to do is bold it. Okay. Now there are 2 questions. Start each question on a new page. Why is that? Well, don't worry about wasting paper. It's just that you would be amazed, everybody, how often I marking papers, I'm not sure what question is being answered. So make sure you make it very clear what question is being answered. And part of that is to make sure you start each question on a new page. Also, the word limit, I forget what it is very generous. Don't worry. I'm always slightly bemused by the number of students who say word count, and it's almost spot on, exactly the maximum word. Okay, so the word limit is generous. You don't have to go right up to the maximum. Stay relevant to the issues in the question. And by the way, don't repeat the question. Your assignment is to hand in the answer to the question, not the question. Okay, so there you are. Don't include the question in your assignment. Okay. No need for footnotes or bibliography. In other words, list of references. Okay, as far as I'm concerned in the assignment, no need to put that down at all. Also, you should look to use suitable headings, and the best headings are always issues. What is an issue? A question for the court to decide. Okay, and if you're going to use subheadings, put them in bold print or underline them at least. Okay. And of course, in question one, obviously, what would be the obvious headings? Well, of course, is there an offer? That would be a useful issue. Has it been communicated? Is there acceptance, or has there been withdrawal of the offer before acceptance? Okay. And in both questions, certainly question one, don't panic if you can't come to a firm conclusion. All right. Now, some students, when I used to work through tutorial questions with students before, they come up to me, Mr. Greenwood, thank you for your tutorial. We almost enjoyed it, but what was the answer to question one? I said, sorry, there is no answer to question one. I said, what? What sort of teacher are you? You don't know the answer. I said, sorry, not enough information. So, even in a court case where the judge has access to lots and lots and lots of information, he will make a decision, and of course that could go on appeal. So if a very learned, experienced judge with access to lots and lots of information can get it wrong, in inverted commas, so it goes on appeal, how can you as a law student doing an exam question with limited facts come to a black and white conclusion? So don't panic if you can't come to a black and white conclusion. If you can identify the issues, and how do you do that? By using your definitions and principles, okay? Then applying that to the facts of the case, arguing both sides, then well done, first class honours, okay? So that's with regard to the issues, and remember the best issues are, best headings, sorry, are issues, and an issue should have a question mark, okay? You know, is there an offer? Question mark. That would be a suitable subheading in question one. Okay, I'm getting confused. Who is the person who makes the offer? What person? Well, that's pretty clear, isn't it? As one offered to sell his car, then subsequently the buyer offered to buy it. Well, no, well, the person who makes the offer originally. Okay, of course, the other person could make a counter offer. That's possible. I don't think that's the case anyway. Yeah, well, a person who makes an offer is the offeror, person who receives it, the offeree. And of course, has it been accepted or not, or might there be a counter offer? If there is a counter offer, then that becomes the offer, okay? Right, the counter offer kills off the original offer. Okay, so there you are. It depends on the fact. So there, I think you'll find that's clear enough in the question. All right, so there you are. Also, the next point about the assignment, normally single space your answers. It's up to you. There's no hard and fast rule here. But it reminds me of a piece of advice I was given by one of my friends when I was studying law. He was a judge, and he said, always better to keep things more compact than spread them out. If you spread something out, it's much more difficult to focus on what you're writing than if it's... No, easier to focus on one page rather than two. So generally I would suggest single space your answers, but leave a gap between your paragraphs. And by the way, have paragraphs. I'll be very disappointed. Well, I'll be really throw up my hands and have to have another cup of coffee if there are no paragraphs at all in your answer. Paragraphs are good, but keep your paragraphs and your sentences relatively short. A paragraph shouldn't go any longer than, I don't know, 10 lines. There's no hard and fast rule, okay? Because the longer your paragraph, the easier it is for you to get confused. You might be talking about more than one issue in the same paragraph, okay? Now, if you're confused, the person marking your paper is confused as well. So in general, keep your paragraphs shorter rather than longer, and keep your sentences shorter rather than longer for the same reason. One of the most famous judges who we've mentioned several times on our courses was Lord Denning. and he was famous for writing judgments and using very short sentences. Okay, and of course, yeah, type your answers. That's it, and of course, keep a copy of your assignment. And so I think that's pretty well it with regard to the assignment. So don't be late. All of you can now do both questions in the assignment. Okay. Now, if you've got any questions about the assignment, you could drop me a line in the chat box, and we'll have our second break now. So if you've got any questions about the assignment, drop me a line now, and I can address them after we have our break. But after the break, we'll be getting on to a discussion about public nuisance. Public nuisance is not in your assignment, but public nuisance obviously is related to private nuisance. So what is the distinction between private and public nuisance? Well, we'll be looking at that in a moment. We've covered, of course, private nuisance, and so we'll be looking at public nuisance, and you'll be able to see for yourself what is the relationship between private and public nuisance. Okay, well, let's have our second break, and after the break, we will get on to public nuisance. Sorry, I forgot to turn on the microphone. My apology. Oh dear. Okay, come on. Should be doing it. All right, everybody. So we're talking about public nuisance, and we're talking about the difference between public nuisance and private nuisance. And as I say, there's a description stroke definition from the English cases. In the well, there's an AG and PYA quarries case on page 109, which something which material affects the reasonable comfort and convenience of a class of Her Majesty's subjects. Obviously, that's English. But the Hong Kong sort of equivalents on page 110, Leung Chung Hung and the incorporated owners of Kwok Wing House. So, Mr. Justice Ribeiro, PJ, pajamas, okay. Permanent judge, okay, permanent judge, not a non-permanent judge. But in the Leung case, Mr. Justice Ribeiro does talk about a state of affairs which endangers the lives. And because it covers endangerment to life, this is why you claim damages for personal injury in public nuisance, whereas you cannot claim damages for personal injury in private nuisance, okay? Remember, what is private nuisance? Unreasonable interference with the use and enjoyment of the plaintiff's land. So in the Hunter case, the court said that you cannot claim damages for personal injury in private nuisance, but you can claim damages for personal injury in public nuisance because it covers a state of affairs which endangers, among other things, the lives, safety, health, etc., of a comfort of the public. Okay. Do you need to remember this? Well, it's probably, yes, just to appreciate that public nuisance covers a much wider range than simply private nuisance. Okay, so there you are. So the rail track and Wandsworth case was adopted by Ribeiro in the Leung case. Okay, so it's something that endangers the life, safety, health, property, or comfort. Also affects the morals, which not actually on the screen. Okay, we'll look at what do you have to prove to succeed in a claim for public nuisance. Okay, we'll get onto that in a moment. Okay. We've got some justification for public nuisance with Denning in the PYA quarries case. So widespread in its range, it should be taken on the responsibility of the community at large. But everybody, two important distinctions between private nuisance and public nuisance. The first one, bottom of the screen, for private nuisance, you can only sue if you have a legal interest in the land. For public nuisance, you do not need an interest in the land. Second big difference between private nuisance and public nuisance, you can claim damages for personal injury in public nuisance, but not private nuisance. And that's because of what's on the screen, because public nuisance covers the state of affairs which endangers the life, health, and property. Okay, so it does cover personal injury. All right, so that's sort of introduction to public nuisance. Now, what must a plaintiff prove in order to succeed in a claim for public nuisance? Well, first of all, he has to prove that the nuisance affects a class of the public. What do you mean by a class? Well, road users, pedestrians, it's pretty broad. The class can be quite broad, but you've got to come within a class of the public. And then the plaintiff has to be a member of that class, and he has to suffer special damage. Okay? And also the injury caused to the plaintiff must be of a foreseeable type. And probably a good illustration of this is the Castle and St. Augustine Links case on page 110. Okay? And in that case, the plaintiff was driving a car on the highway. He was hit and injured by a golf ball. hit off a golf tee. So it was held that the plaintiff was entitled to succeed. Well, number one, he was in a class of the public, in other words, a road user, okay, and he was a member of the he suffered special damage because he's hit of him. He was actually hit. Goodness. The ball hit him. Anyway, that seems to say, right? The location of the golf tee was the source of nuisance. So he was a member of the class of a public affected by the golf tee, namely highway users. He was a member of that class. He suffered special damage over and above that of other highway users. But you have to be pretty unlucky to be actually hit by a golf ball. Must have had his window open. Well, even if it was, so he could claim damages for personal injury. Also, if his car was damaged, he could also claim damages for property damage. So Castle is a good illustration of a successful claim for public nuisance. Okay, so there you are. And also, it was personal injury. So remember, he doesn't need to show he owns land. He just has to show he's a member of a class, highway user, and he has to show, though, that he has suffered special damage. And the special damage was his personal injury. Okay, so, and it was an injury which was of a foreseeable type. Okay, good. So I trust everybody you can hear me all right now. So my microphone hopefully is working pretty well again. All right, so there you are. Let's have a look at some examples of public nuisance cases. And this is sort of a sample. Some of these are in your course manual, some are not, but Mack and Chung was a car crash in which somebody failed to move their car off a highway. Oh, Ring and Cohen is the interesting one. Structure overlooking a highway. Now, if you drive along a highway in Hong Kong, often there are walkways that go over the highway. Well, there could be something on that walkway, which, flower pot or something, which could fall onto the highway. That will be in the form of public nuisance. Okay. Also, there's a Hong Kong case called Chung and Sion, similar to Ring and Cohen, where something on a public highway caused damage. Okay. Leung and Chair is a Hong Kong case dealing with buildings collapsing. So obviously that is a form of public nuisance. Okay. But then Leung and Lee and the incorporated owners of Kwok Wing House, that's a good one, because in that particular case, it's actually Lee. So I'm reading on page 111. A defendant, again, what would happen here? The plaintiffs were administrators of the victim, Hawker, that's right. She was killed when she was struck by a piece of concrete weighing 15 pounds that fell from the 11th floor of Kwok Wing House. So the piece of concrete was from a canopy projecting out from the enclosed balcony, which was an illegal structure, not having been authorised by the building authority. So the trial judge found, as a matter of fact, that the concrete fell as a result of want of repair. So illegal structures, unfortunately very common in Hong Kong. So the plaintiff sued the owners and tenants of that particular flat and the incorporated owners of the whole building based upon negligence and public nuisance. And at trial, through appeals, the parties agreed the liability of the incorporators can only be on the basis of public nuisance. Okay, so there's Mr. Justice Ribeiro on page 112. The incorporated owners were liable for the nuisance based upon omission and that they failed to take action against the illegal structure in Flat A. It was within their duties and power to intervene as incorporated owner under the Building Management Ordinance, as well as the deed of mutual covenant for the building in question. Now, what is the deed of mutual covenant? It's an agreement between all the unit owners in a multi-story building, and it governs the right and obligations of all the unit owners, and also governs the operation of common parts of a building. That's the deed of mutual covenant. Okay, so that's a good Hong Kong example of public nuisance. But I think the castle case is probably good enough as well, going back. The castle case is pretty easy to remember, okay? So when you're driving along a highway, quite often there is potential for an action in public nuisance. For example, if you're ever driving behind a truck, particularly one from a construction site, they might be dropping rubbish onto the road. This happened to me once when I was driving along, and something fell off a truck, and you were lucky to avoid it. But if it actually hits your truck or car and damages your vehicle, or indeed if you suffer personal injury, you could sue in public nuisance. But as I say, the problem might be, can you identify the person who's responsible for creating that hazard? Okay, I mean, you're probably focusing on avoiding whatever's been dropped in front of you. You don't catch the number plate of the vehicle which dropped that particular hazard on the highway. Okay, so watch out for highways. That's very important. So there's some examples of public nuisance cases. And then, so they're the other cases. And then with regard to remedies for public nuisance, well, similar to remedies for private nuisance, the most common remedy for public nuisance is usually an injunction, again, but also an individual may sue in his own name to recover damages if you have suffered particular damage. It could be either physical damage to property or it could be personal injury. Okay, so they're the remedies for public nuisance. I'm just checking that Corby case, whether I've actually got it. No, okay. But if you have a look on page 115, talking about remedies for nuisance, also onto page 116 and 117, injunction is usually the best remedy for either private nuisance or public nuisance. Okay? But if you do suffer particular damage in public nuisance, whether it be personal injury or property damage, you can claim damages. You can even claim pure economic loss damages. That's the Lam Yuk Fung Attorney General case. All right, so the remedies for public nuisance are fairly similar to the remedies for private nuisance. The most common remedy and the most desirable one normally is an injunction, although probably more commonly for public nuisance you can claim damages because you have suffered some damage, whether it be personal injury or property damage. Okay, so the remedies for public nuisance fairly similar then to the remedies for private nuisance. Okay, everybody, now let's, before I finish for today, let's have a quick look at a case which illustrates the overlap between private and public nuisance. Again, Lam Yuk Fung and the Attorney General, this was a case dealing with smut from an oil depot, okay, and it caused damage to property, and of course that would be in the nature of private nuisance, so the property owner could sue in private nuisance, because you know what private nuisance is, don't you? Unreasonable interference with the use and enjoyment of the plaintiff's land. Okay, but there was also damage caused from the smut from the oil depot to the particular person's car, which was parked in the street. So could he claim damages for damage to his car parked in the street? The answer was yes, but this would be the action for public nuisance, okay? Because his car parked in the street, you don't own the land, you don't own the street itself. But you would be in a class of the public, namely people, highway users, road users, and you would suffer special damage. And if your car is actually damaged, then you can claim public nuisance. So in the Lam Yuk Fung AG or HK case, that particular person could sue in both private nuisance and public nuisance. He would sue in private nuisance for the damage to his own property, and he could sue in public nuisance for the damage to his car, which was parked in the street. Okay, all right, and then to finish off with everybody, sort of on a general point about pollution. When we're talking about statutory nuisance, we're sort of getting into the area of, noise pollution, air pollution, all types of pollution, okay? So again, should know, not must know. You might be examined on this. But from a broader point of view, public nuisance does sort of impinge into areas dealing with control of pollution. Okay, so how are we doing? Oh, not too bad. So just to sum up, sort of flipping back through public nuisance, sort of by way of revision, and we'll look at this again when we meet for the last time, before the revision course, that is, we will look at public nuisance when we meet again next Tuesday. Is it Tuesday? Yeah, Tuesday next week. So Tuesday next week, we'll review both types of nuisance, and then I will go through occupier's liability. And the reason why I'm going through occupier's liability is it's not must-know occupier's liability, but in a way it's a good revision of negligence, because a lot of the issues with occupier's liability crop up with negligence. So it's a good way of reviewing our work we covered on negligence. Okay, hang on, I've got a question. How about I determine whether the plaintiff is oversensitive? Well, it depends on the circumstances, okay? We'll block the ventilations. Well, by the way, you have that could really be physical damage to the land, so I would think you wouldn't have to worry. Well, and of course, with regard to abnormal sensitivity, it's really a question of fact, okay? The court will judge it by the standard of an ordinary person or ordinary building, okay? And with regard to abnormal sensitivity, remember, if you are a shift worker, then you'll still be judged as if you're an ordinary worker who sleeps at night time and works during the day, okay? But the leading case on abnormal sensitivity, Robinson and Kilbert, okay? Also, Capital Prosperous and Sheen, remember, ordinary people in Hong Kong go to bed late, okay? Okay, so that's, I'm looking at the chat box and learn questions about abnormal sensitivity. Do we have to raise the possibility in the assignment then? Of what? Do we have to raise this possibility? No, in the assignment, I don't think. Well, it could be. I forget what the question is now. But remember, how does the court decide? Well, it's unreasonable interference. So what is unreasonable? Well, the court will decide, what is the situation of, an ordinary plaintiff. And we'll look at ordinary circumstances. Ordinary people sleep during the night time and are awake during the day, for example. Robinson and Kilbert, the court looked at the effect on ordinary paper rather than heat-sensitive paper. So it does depend on the facts, okay? But remember, if there's actually property damage to the plaintiff's land, that is unreasonable, full stop. You don't need to go into any of the factors. So remember, ACL and Bulmer says if there's actually property damage, then that's unreasonable. I like the English case, though, St. Helens smelting and tipping. Okay, so yes, apply that to the question. I forget what the facts were. But remember, the other important thing about private nuisance, only people with the legal interest in the land can sue. All right, so going back to public nuisance by way of revision before we start winding down for today. Remember, public nuisance, probably the best way of tackling public nuisance, first of all, is the definition, okay, which is sort of the one that's followed both in England and Hong Kong. It endangers the life, health, property, morals, or comfort of the public. So it does cover, the morals bit covers, that bit about people objecting to a vice establishment being in their area. Okay. Or comfort of the public, or to obstruct the public in the exercise of enjoyment of any rights common to all. That would be interesting. I mean, we're all entitled to exercise in a public park, for example. There's some instruction there you could sue, but you have to suffer special damage. Remember, if you're going to sue in public nuisance, you've got to show special damage, whether it be personal injury or property damage. Okay? And also remember, you can claim damages for personal injury in public nuisance, but not private nuisance. So as in the Castle case, the highway user, he did suffer personal injury. I wonder what his injury was. He must have been hit in the head or something. Couldn't have done too much damage, a golf ball, I don't know. But he could claim damages for personal injury in public nuisance. Remember, though, you cannot claim damages for personal injury in private nuisance. That's the important point to make. And also the other big difference between private nuisance and public nuisance, of course, is that for private nuisance, you've got to have a legal interest in the land. Okay, so the definition of public nuisance, going back, is much broader. Should know, not really must know, the description of public nuisance, but appreciate that public nuisance is there to cover a wide range of interests, not just property. Okay, whereas private nuisance is just there to cover property, effect on property, effect on land. Because remember the definition of private nuisance, which you know is must know, unreasonable interference with the use and enjoyment of the plaintiff's land. Okay, good. So whenever you're doing any question with private nuisance, first thing you do is write down the definition. So that's the first thing you should do in question 2 of the assignment. And then remember with private nuisance, the two big issues, does the plaintiff have an interest in the land? Okay, who can sue? Malone and Lasky, Stroke, Hunter and Canary Wharf. And the other big issue, of course, is there unreasonable interference? Well, it does depend on the facts of each case. And remember also, and this is relevant to your assignment, he who asserts must prove. So if you are advising somebody who wishes to sue in private nuisance, they have to prove the elements. They have to prove, in particular, unreasonable interference. But of course, what do you mean by unreasonable? Turns on the facts of each particular case. So you need to have pretty good evidence. Okay? With regard to public nuisance, though, by contrast, there's no dead set definition, but you can describe it as a state of affairs, what's on page 110, which endangers the lives, safety, health, property. It doesn't actually mention morals in Ribeiro, whereas the English one does cover morals. Otherwise, they're pretty similar. Okay, and also with regard to advising a client in public nuisance, you've got to satisfy those 3 requirements. You've got to satisfy the fact that you're a member of a class of the public, whether it be a highway user or park user, pedestrian. Okay. And then you have to prove, once you're a member of that class, that you have suffered special damage, whether it be personal injury or property damage. And of course, the injury must be of a foreseeable type, which is normally not that difficult to prove. Okay, if you've suffered personal injury. So good PowerPoint, this one, on what the plaintiff has to prove to succeed in an action in public nuisance. So over the weekend, what's left of it, if you're going out and about, ask yourself, hang on, might there be an instance of a claim in public nuisance? For example, let's say you park your car in an outside car park and, there's something damages your car. when you're parked in the public car park? Well, you could sue in public nuisance. You don't have to own the car park to sue in public nuisance if you suffer special damage. Okay, but I like those other pigeon droppings. That's an English case in which there are pigeon droppings onto a railroad and that caused some sort of damage. Okay, not maintaining a refuse depot, pollution, dropping objects from a building. That's a pretty common type. What do you mean by special damage? Well, special damage would be personal injury or property damage. That would have to be it. You could claim for economic loss, but only as a result of the personal injury or property damage. It'd have to be directly connected. Okay, everybody, so that's pretty well covered nuisance today, both types today, and we'll be reviewing both types of nuisance next time we gather, albeit online, virtually, next Tuesday. So we'll review private and public nuisance, and then we will cover occupiers liability and probably have a short time left for a quick review in general of negligence. Okay, so good question from Low Intention. Special damage means personal injury or property damage. You can claim economic loss, but only as only the loss that's a direct result of that. You wouldn't be able to claim pure economic loss, because pure economic loss, remember, is not a result of personal injury or property damage. Okay, well, thank you very much, everybody. Lovely day outside. So if you're going out hiking, be careful. If you do suffer damage, you might be able to claim in public nuisance, okay, depending on what your activity is. All right, so thank you very much for your attention. Go and do your assignment. That's my suggestion. You all can do question 1. You all can do question 2 right now, okay? The issues I've suggested are pretty clear. Follow my guidelines, which I talked about before, and don't include the question in your assignment answer, okay? Just include the answer. You don't need to include footnotes or bibliography. Okay, so that's it for everybody. Enjoy doing your assignment, okay, and get them in on time. You've got plenty of time, goodness gracious. Not until the 23rd of March. So I will be seeing you next Tuesday, and that will be our final sort of formal lecture. And then we have 2 more revision classes. And in the revision classes, I'll take you through examination technique, and then also I'll cover the must-know parts of both the contract